Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinsky, the former practice group leader for 25 years and now Senior Counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. We've hosted the blog since 2011, so there's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you obtain your podcasts. And please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. Well, the topic today should be very, very timely. We have been following ever since President Trump was sworn into office on January 20th. What was he going to do about the CFPB? A lot of people, including myself, thought that he would basically appoint somebody to run the CFPB in a manner similar to the way Mick Mulvaney and Kathy Craniger managed the CFPB during his first term. That is, there would be no pushing of the envelope. They would not be involved in taking extreme positions, but they would continue to run the CFPB largely the way it had been run under prior presidents. And they would maintain roughly the same number of employees, and they would conduct examinations, and they would bring enforcement matters. But as I said, in the enforcement area, it turned out that while they did a lot of enforcement work, they tended to focus on the out-and-out fraud, not positions like Rohit Chopra has taken during his term in office, where he was always seemed like he was trying to break new ground. So I was wrong. A lot of people were wrong. Right from almost the very beginning, he took a lot of steps that seemed to be going in the direction of shutting down the agency. It didn't take very long. It took a couple of weeks before he fired Rohit Chopra. And for one weekend, he installed the Secretary of the Treasury, Scott Bessent. And then after the weekend was over, he installed Russell Vought. And Russell Vought has been acting director ever since that time. There's nobody right now that has been nominated to fill the position. And I don't think the administration is in any big hurry to appoint anybody. And my guess is there aren't going to be very many people, certainly any qualified people, who are going to be very interested in taking on that role at this juncture. Litigation ensued, and a very, very fine plaintiff's attorney, who I happen to know very well, Deepak Gupta, became the lead plaintiff's attorney, or his firm did, where he represented the labor unions that represent CFPB employees, and he brought a lawsuit in federal district court, District of Columbia. It got assigned to Amy Berman Jackson, very, very good judge, I would say, probably on the liberal side. And the lawsuit began in earnest and went pretty well for the plaintiffs and the unions in front of Judge Berman. And she had issued a preliminary injunction. I'm going to get to that in a minute. But before I do that, let me now introduce our special guest for today. And it's just going to be, this is going to be fun because it's usually I've got more than one guest on a program. And today I just have one guest, but I have a partner in our firm who has been following what's going on with the CFPB for his clients very, very carefully. I would say almost every single move my guest, Joseph Schuster, has been tracking, has blogged about, has spoken on other webinars and podcasts about. And so, without further ado, Joseph, a very warm welcome to you. And thank you very much for agreeing so quickly to be part of what I consider to be a very important podcast show today.
Thank you, Alan. Yeah, it's great to be back on the show with you. I know that we've discussed this case previously on this podcast, and I agree with you. This is going to be fun, both this podcast and where things continue after this. There's a lot in this case where it is right now. I think that our listeners, those who are in the industry certainly, are going to be reacting and thinking about this in a number of different ways. So look forward to discussing this with you.
So what prompted us to do this podcast right now and to release it very quickly is that on August 15th, the United States Court of Appeals for the District of Columbia came down with its opinion, 2-1 opinion, majority opinion, written by Judge Katsos, joined in by Judge Rao, and there was a very stinging dissent by Judge Pillard. And although it shouldn't be relevant, but I think unfortunately it might be, both of the judges who were in the majority were appointees of President Trump during his first term. Judge Pillard was appointed by President Obama a while ago. A very, very capable judge, Judge Pillard. She used to be at Georgetown Law School and headed up the sort of a Supreme Court practice that they had there for law students at Georgetown. In any event, opinion comes down on August 15th. And as I said, this was the appeal from an opinion and order of the district court with Judge Amy Berman Jackson presiding, in which she found that the acting director had made a decision to shut down the CFPB. And she entered a preliminary injunction severely restricting agency actions, among other things. The preliminary injunction required the CFPB to reinstate all probationary and term employees. There are about 85 people. They had already been fired and they had left the agency. And that had happened after February 10th. Also, the injunction refrained or prevented the CFPB from instituting any kind of work stoppage. There had been a complete work stoppage at the CFPB where people were staying home and they weren't allowed to do any work at the very beginning, even work that was statutorily required by the Consumer Financial Protection Act. Also, there was an injunction that would prevent the CFPB from rescinding all third-party contracts that they had entered into. Some of them very, very critical contracts pertaining to the maintenance of the consumer complaint portal and contracts that they needed in order to continue to prosecute certain enforcement litigation. There was a mandatory injunction to provide CFPB employees with either fully equipped office space or the means to work remotely and to maintain a toll-free telephone number, website, and database in order to respond to consumer complaints. The government appealed, and it moved for an emergency stay. The Court of Appeals granted a partial stay that was joined in by, I believe, all three judges that allowed the CFPB to terminate employees or to stop work if the agency determined, after what they called a particularized assessment, I don't know what the heck that means, that the employees or work at issue were unnecessary to the performance of the CFPB's statutory duties. Days later, the agency issued a reduction in force, or from now on, we'll call it a RIF, and they gave that notice to more than 80% of the workforce, which combined with the people who had already been fired would have resulted in the elimination of 90% of the existing workforce and would have left about 10% or about 200 employees left. It became very, very difficult for the Court of Appeals to manage that order that would have allowed exceptions to the prohibition against doing a RIF, and they ultimately decided to get rid of that partial stay, leaving the RIF for the time being fully intact until they had decided on the merits, the motion for a preliminary injunction. So my question for you, Joseph, and I know it was a long-winded introduction so that we could get to you, but can you tell us the opinion by the majority, the 2-1 opinion? What was the basis upon which the majority reached their conclusion to vacate or dissolve the preliminary injunction in its entirety?
Sure. Great question, Alan. And like you said, it is a very lengthy opinion. It is very repetitive, though, and I think that I can boil this down to like 2 points. However, before I do that, I'm just going to react to a couple of things from the introduction. I think that you shared that your view and a lot of people's view was that the CFPB was going to continue similar to how it had previously existed, with employees but changing priorities. The thing that I think that we failed to kind of take into account was how politicized Rohit Chopra made the CFPB while he was director at the CFPB. And that, I think, really changed. I think the CFPB has always changed with different administrations, but it became much more politicized over the past several years. And I think as a result of that, we are seeing a swing in the other direction as well that we might not have seen had it not been for that extreme, in my view, politicization of the CFPB over Rohit Chopra.
I always wondered about that, and I'm glad you mentioned that because, as we all know, we could do a separate program. The things that Rohit Chopra did during his tenure, and it seemed as his term was drawing to an end, he started accelerating. It's like he was on a treadmill, and he jacked up the speed, maybe doubled it. And it seemed every day there was something going on, and it was something that was objectionable. A final regulation, proposing a new regulation, coming out with guidance, giving a roadmap to state attorneys general on how they could fill the void if a void got created. Oh, it went on and on and on. And I'm wondering that if he had been more like Richard Cordray, who was the first director of the CFPB, who was no pushover, for sure. He was tough, but he didn't, I think, offend people and didn't politicize the agency as much as Rohit Chopra had done. You agree?
I think that's exactly right, Alan. And I think that goes to, we saw a lot of challenges to some of the things that Rohit Chopra is doing under the Administrative Procedures Act, that there were rules being promulgated that did not follow a notice and comment period. So there were specific actions that were being done that the allegations were that they did not follow the Administrative Procedures Act.
Yeah,
and this gets me into
another terrific point, because if you go back and you look at what Cordray did during his term, he promulgated a lot of regulations, a lot of them, particularly in the mortgage area initially, and there weren't that many lawsuits. They just, things seemed to get worked out. He seemed to be more willing to engage with the industry and not necessarily say it's my way or the highway. And, a great point. I'm glad you mentioned that as an initial point before getting to what Judge Katsos had to say in vacating the preliminary injunction. But let's get to that. What did he hang his hat on here?
Well, and that's why I bring up what happened and the Administrative Procedures Act, because there's kind of two things that happened. The first one is saying that there has not been a final agency action that's reviewable under the Administrative Procedures Act. That is one of the claims, that the agency is being shut down and that it cannot be shut down in this manner without going through the Administrative Procedures Act, without congressional involvement. So, it's interesting that we're seeing the use of the Administrative Procedures Act being asserted in this way for, as they said in this opinion, something that hasn't really happened yet, but really a lack of action, whereas if the APA was being used during Rohit Chopra's administration because of the specific actions and saying that those were also not following the APA. So it's interesting that we were looking at it in those two ways. The other piece that was involved was a claim for the loss of employment. And there, the opinion really says that it's not that the court doesn't have jurisdiction over this one, that there's a specific path for this review under the Civil Service Reform Act, and there's nothing really that this court can look at with this. There's no legal basis for an implied equity claim under the Constitution in that. So you have kind of those two pieces. And the APA one is, I would say, the larger one that's discussed more throughout this opinion and in the dissent.
And I think it's important to note that the APA claim, it was basically a claim that the CFPB had been shut down or was in the process of being shut down. And included in that certainly was the firing of those 85 employees at the beginning and the intention that seemed to be there already to engage in a riff. They already had Elon Musk and Doge enter the Bureau and do whatever the heck they did. I'm not sure what they did, but it seemed like they were headed in that direction. So, yeah, and some people have characterized their reasoning as being hyper-technical, that they seemed to be trying to focus on this theory that's well established that under the APA, you can only attack a final ruling. It doesn't have to be a regulation, but it's got to be some final decision. And they were saying, it's just not final yet. Yeah, there have been all these things that they're doing, and they came out with a change in policy. They were dealing with supervision and enforcement, but nothing's happened yet. But yet, when you think about it, the whole idea behind the lawsuit was to prevent bad things from happening. And so was Deepak Chopra or Deepak Gupta, did he have to wait until the animals had all left the barn before trying to close the barn door? What do you think?
Well, number one, I like the analogy, but I think that it's unclear whether this would have shut down the CFPB. I think that in most of their orders and memos to staff, they've talked about continuing to do their statutory responsibilities, the CFPB's statutory responsibilities. If there is a RIF of these employees, there will still be 200 employees remaining at the CFPB. Can 200 employees do the statutory requirements of the CFPB? Maybe. Are they going to hire more people, and replace perhaps some of the previous administration's, I won't say cronies, but like people who may have had the view of the previous administration with people who have the view of this administration? That's possible too. So I do think that it may be premature to say that the CFPB is being shut down. I think that as we looked at and we discussed on a previous podcast, what Amy Berman Jackson did really said that the CFPB had to continue a lot of the things that they were doing under Rohit Chopra. I think that in this opinion, they talked about that it's not the task of the judiciary to decide the resources of an agency or whether an agency should be doing something in a different manner.
They weren't going to micromanage, right?
Exactly. Yes. And so I think that there is merit to say, is the CFPB being shut down? Does the CFPB have to exist in its current form? Absolutely not. But it does need to meet those statutory requirements, and it may be able to. We have to wait and see.
Okay. Let's turn now to Judge Pillard's dissent, which was quite a tome in and of itself. And first of all, what did Judge Pillard rely upon after she got her vitriol out of the way? I mean, she was obviously, I think, very angry with how this case was turning out.
Yeah. I mean, she believes that the agency's adoption of a plan to, in her view, abolish the CFPB was itself a reviewable final action. And that even though there was nothing written or no formal plan, that did not mean that there was not an adoption of that final action that could be reviewed. I want to just read one brief quote from her dissent, Alan, if you don't mind. It says, "The president's chosen CFPB leadership may run the Bureau as it determines best serves the public interest, but it is emphatically not within the discretion of the president or his appointees to decide that the country would benefit most if there were no Bureau at all." I'll note in there, and this really, I think, summarizes where she goes with the dissent, in that she believes that the decision was made to shut down the CFPB. I think continuing to have 200 employees, there is still budget there for those 200 employees. There's not been any, and in fact, this was discussed in the opinions, that there's nothing on the record where the government has said that they are going to shut down the CFPB in its entirety. Nonetheless, I think that her view is that there was a final action to shut down the CFPB, and that is an unlawful action.
And it doesn't have to be memorialized in some document that gets published in the Federal Register. It can be done informally, right?
Exactly. I think, though, again, both of these, you have that procedural piece, but you also have the question of, would this action have shut down the CFPB? And I'm not sure that it would have. So I do think that is something that, when we'll talk about possible continued litigation throughout the podcast.
It would have completely transformed the agency from what it looked like under Rohit Chopra. But it's unclear whether it would have prevented the CFPB from performing the functions that were statutorily required. There's a lot of discretion that the CFPB director has, and certainly prior directors, and most notably Rohit Chopra, used a lot of discretion, but that doesn't mean that all the things he did, he was required to do. He did a lot. So, yeah, I mean, your point's a good point. And, and maybe at this juncture of the litigation, it's not that clear if they're able to perform with 200 employees and how many banks they'll be able to supervise and examine. And, they've actually just the other day came out with their semi-annual regulatory agenda. I don't know if you had seen that, but it was actually pretty lengthy. They've got to deal with 1033, dealing with open banking, 1071, dealing with data collection for small business lending. They have proposed to change larger participant rules for 4 different sub-industries and to cut back on other regulations. And that all it requires people to do it. And so, we don't know, right, based where we are today, what they're really capable of doing.
I'd add on that, too, if you don't mind, on the rulemaking priorities. There are things in here that are discretionary as well. You said it's fairly lengthy. It includes 24 action items for the CFPB. One of them includes broader UDAP rulemaking efforts, which is entirely optional. It's possible that they'll come up with rulemaking and...
Yeah, well, why don't you, if you don't mind, Joseph, since you have it handy, maybe it would be useful, because I know a lot of people have had trouble accessing this regulatory agenda. There was some kind of technical glitch where you would ordinarily be able to access it. and it was not available for a few days. And some people were able to take some screenshots. I saw it and I was a little bit blown away. It was a lot lengthier than some of the other ones under Chopra or Cordray. So what's in there?
Well, I think the things that you mentioned are certainly in there. Things involving personal financial data rights, the small business lending data collection under ECOA, reconsidering that. There's reference to the payday vehicle title and high cost installment loans, reconsidering where that rule is going to go. There's discussion of the Equal Credit Opportunity Act, and that might be implementing President Trump's executive order of moving away from disparate impact theory. We've seen a lot of things happening in the world of where fair lending is going, both at the federal level and at the state level. There's a very interesting dichotomy that we're working with clients on between those two. The UDAP that I mentioned as well, there's things under the FCRA and Reg V about identity theft and coerced debt. And there's a number of things relating to mortgages, RESPA, and things of that nature as well. So like you said, Alan, it's lengthy. There's a lot in here. Are all of those employees who would be subject to a RIF involved in this? I highly doubt it. So, it's interesting. It's possible that the CFPB could do more with less. And there's a great graph that shows the employees that the CFPB has had over time. It's waxed and waned, but I think it remains to be seen where things go.
Yeah. Well, let's now look toward the future. Okay, we got the preliminary. This litigation's been ongoing for months, and we're sort of finally at the point where there is no preliminary injunction, but the plaintiffs still have options available to them. It's not like the litigation's over. You'd read the 109-page opinion, you'd think, geez, that's got to be the end of the lawsuit. It's not, right? So what are the options, Joseph, that are available? And I'd love you to handicap what you think they are going to do, Deepak Gupta, and what you think their chances of success might be.
Yeah, absolutely. I mean, this has been ongoing for quite some time now, and I'm anxious to see if it's ever resolved in a final form during this administration. The current where they can go right now is that this mandate is delayed until 7 days after the disposition of any petition for rehearing amongst these three judges. I think that's unlikely, or disposition of a petition for the full Court of Appeals to hear this case. And there, I think that is more likely. They have 45 days, which I believe takes us to around September 29th for them to file this petition. As you look at the composition of the Court of Appeals, there's 11 judges. 7 of them were appointed by Obama and Biden. You only need 6 votes for rehearing and banc. I hate to say it, but I put those odds at 50-50 on this one with some of the things that have been happening. I think that some people are pushing 51-49 in favor of the rehearing and banc. That might be the case, but there have been a lot of things happening with respect to reductions in force and addressing the number of government employees. And so I'm not sure that they will necessarily want to go down that path as well. The other thing that they could do is they could file a motion with the Supreme Court to stay as well. I think that is less likely than filing a petition for the full Court of Appeals to hear.
They will get, yeah, you're right. I agree with you. I mean, they try to get us some kind of relief from the U.S. Supreme Court. I think the odds of that happening, in light of what we've seen the Supreme Court doing in other cases, I think it's about nil. There's no chance. And I agree with you. It's about a 50-50 chance that they'll get a petition for they won't get a rehearing before the same panel. There's no way this panel is going to revisit this. But rehearing en banc, you've got still a majority of the active judges that are Democrats appointed by Obama and I think Biden. I don't think Clinton has got any appointees. And there are, I think, 4 judges appointed by Trump and maybe 1 appointed by Bush Jr., second Bush. If it gets decided politically, if it's a political decision, they will probably grant rehearing en banc. I mean, there are 2 things that could happen here. They might grant rehearing. I think the odds of them getting a rehearing on banc are probably higher than the odds of them actually getting the full court to completely overturn what happened in front of the panel. Because, it's that's, I think, more likely to be a political decision, just granting the rehearing on banc. They don't have to write an opinion in connection with it. I'm sure the Democrats on the court all have a lot of respect for Judge Pillard. And, there's, like everything else, our country's very divided, and the courts are very divided in their thinking.
Alan, I think it's a great point, and I agree with you. I think that the granting the petition for a rehearing en banc is more likely than being successful when the court does hear this. Because remember, again, you have to convince the court to infer a shutdown of the CFPB in order to make this finding under the APA. I think that is a tough case to make.
Right. But in the meantime, I guess if you look at it, even if ultimately Deepak Gupta is not successful, there is one thing that he has done. And if you're one of those employees that's on tenterhooks, and because you're afraid you're going to lose your job, you don't have another job, these people are still employed and they're drawing a paycheck. And the longer that can get delayed before the RIF actually happens and they're shut off. And I guess maybe with the RIF, they even get some severance pay. I'm not sure how that works. But if you're one of those people, you're happy with any kind of delay, right? I mean, that's probably more important than anything.
I think you're right, Alan. And we have seen a number of people leaving the CFPB voluntarily. A number of our clients have hired people who were previously at the CFPB. Employees are taking jobs elsewhere. So I think you're right, but I also think that there are a number of employees who may not want to be sticking around to see what ultimately happens from this.
Yeah. So I want to look at examine one other alternative. We've looked at petition for rehearing en banc. We've looked at seeking relief from the Supreme Court, probably on the emergency docket or what they call the shadow docket, not a petition for certiorari, because ordinarily the Supreme Court does not grant cert on what I'd call a interim relief. They wait till there's a final judgment. But they use the shadow docket for exactly things like this that have already come up there. But what about the idea? This is an idea I came up with as I was writing something on LinkedIn. We had Consumer Finance Monitor. We had published a post on there about this opinion. And I put that post on my LinkedIn page and I titled my remarks, "It ain't over till it's over, Yogi Berra." I don't know, maybe you're too young to remember Yogi Berra, but he was a very famous catcher for the New York Yankees, later a manager. And he had all these sayings, these things that he used to say that literally didn't make a lot of sense, but they were known as Yogi Berrisms. So anyway, so I said, well, okay, I think Gupta will try to get this thing overturned by the full court. Failing that, and maybe even in lieu of it, he says, let's litigate. Let's litigate the case, all right? I don't think this is the route he's going to take initially. And also, who knows how deep the pockets are of the plaintiffs in the case that have been financing the litigation. But we go back to the lower court, and we're very early in the case, and the answer gets filed by the CFPB, of course, denying everything. And then discovery begins. And then presumably the CFPB, with there no longer being a preliminary injunction, will start taking steps to make the CFPB fashioned in its image rather than as it exists today, with all these employees that they really don't need, who aren't doing any work. And my thought is the CFP is going to start doing things. And they better be ready to justify the moves that they're going to take, because everything they do is going to be subject to discovery. And there could be another motion filed for a preliminary injunction where they do something that is actually final, where they go overboard. They lay off too many employees. People start complaining. No examinations are being done of large banks. The complaint portal is broken down, not working. It needs to be repaired, yada, yada, yada. And things could change, right? What is now not a final opinion or a shutdown could become a de facto shutdown. What do you think of that, Joseph? Does that make any sense to you, or am I going really far out on a limb here?
I think that makes complete sense. And I think that's a little bit of what this opinion said, that if there are things where the CFPB is effectively shut down or is not following a specific statutory requirement, that's when an action could be brought alleging that specific item. We have not seen that happen yet. So yes, I think that if that happens, and that has happened previously with the CFPB, that they did not engage in rulemaking that they were required to engage in under Dodd-Frank. So having more specificity in the lawsuits as opposed to, we don't think you can do something, maybe they can. So I think you're absolutely right. If they start failing those statutory duties, we're going to see this litigation continue.
Then there's another issue that I think is lurking in the background. Maybe it's not so far in the background, really wasn't dealt with so much by this opinion, other than it was mentioned that Russell Vogt made a decision not to seek his quarterly funding from the Federal Reserve Board. And one other thing that also is not mentioned is that in the big, beautiful bill, the cap, the annual monies that the CFPB can get from the Federal Reserve Board got cut just about in half, okay? From about a little over 800 million, down to about 400 and maybe 50 million a year. So that's a significant cut. None of that's dealt with in here, but one wonders, is the CFPB soon going to run out of money? I don't know how much it's got left. It can't be a lot. And they still have this huge payroll to deal with constantly until the RIF takes place. Now, we got the fiscal year of the CFPB in the U.S. government ending at the end of September. And we have a new fiscal year starting. Will Vogt decide he's going to take some money, because he's going to need the money? Even if they cut the number of employees down to 200, they still got to pay them. And they still got to have other operating expenses, and they have to house them. And I don't know basically where they're going to house them. They already got rid of their main building. So how does that... how do you think that plays into this? I know Evan Weinberger posted something on LinkedIn saying, you also got to think about money in the budget.
I think you're absolutely right. You do have to think about money in the budget. I would remind our listeners that when acting director Mick Mulvaney was at the Bureau, he also declined to request funds from the Federal Reserve for the second quarter of fiscal year 2018. So, this has happened before, with his view, and what Vogt is saying, that instead they're going to use unobligated funds. I think it's unclear what the savings are from not having that big, beautiful CFPB headquarters in DC, from some of the people who have left voluntarily, from some of the contracts that have, some of them have, that they have to maintain some of those contracts. But I think that there were some very expensive contracts out there for evaluations of different practices, different industries that were optional. And so there may be some savings there, but I think you're right that they are going to have to keep an eye on, if they do need to request funding in order to, again, and I think that this is a big focus of what we've been talking about, continue their statutory obligations. So.
Yeah. And, I guess you could say it's an implicit statutory obligation to take and draw enough money that's going to be necessary in order to perform the statutory obligations, right? So, vote is going to be in sort of a catch-22 position. I'm sure he'd like not to take a dime for the next first quarter of the 2026 fiscal year. But if he doesn't do that, he might be creating a pickle for himself, a real problem down the road.
If the courts continue to require the CFPB to operate in a manner similar to what Rohit Chopra created, I think it's going to be a real problem in terms of money. So I agree with you.
Right. All right. So let's talk just a little bit to the extent that we can. People are, I don't know about you, but I get bombarded with questions by clients all the time who want to know what's actually going on at the CFPB. Are there things happening there? You talked about the semi-annual regulatory agenda, and they certainly seem to have a lot on their plate. Haven't seen much happen yet, except, repealing guidances, a whole bunch of guidance that didn't constitute a full-blown regulation that they could just do on their own without seeking comment. For example, the complaint portal. There was a lot of problems at the beginning. The complaint portal didn't seem to be working. Now I think it's working. And ironically, one of the things I read is that the Republicans in Congress are encouraging their constituents to send complaints to the CFPB, which I, thought it seemed a little strange to me. But do you know, are complaints being processed? Is there follow-up? Are people getting any kind of redress, financial or otherwise? What have you heard?
Alan, it's a great question. The complaint portal is up and running. Keep in mind, the complaint portal really facilitates complaints from consumers through the CFPB to the underlying financial institution. And those financial institutions then have a responsibility to respond. That is still happening. How the CFPB uses those complaints, I think we've seen that kind of change under different administrations. Under Rohit Chopra, if there was one complaint about something, regardless of the amount of truth to it or evidence to back it up, they would go after that financial institution. We're not seeing the complaint portal used in that same way. But let me address your broader question, though, of what we're seeing from the CFPB. I'd say there's kind of four things that I'm going to touch on here. There's the CFPB, the DOJ, the FTC from the federal level, and then the fourth one is the states. So the CFPB, we are seeing reduced, really almost non-existent examination and supervision. There is a little bit out there that's kind of happening, some follow-on items.
Let me just add one little footnote to that, and then I want to hear what you're going to say about all the different parties that are involved here. And that is, Trump came down with an executive order, I guess it's about a week ago, maybe it's 2 weeks ago, dealing with debanking. And he has instructed all the federal regulators, and that would include the CFPB as well as the prudential banking regulators, to go back and look at all the banks that they supervise and examine and see if there's evidence of debanking. And it sounds like they can't ignore that. That's going to require a lot of resources, I would think, to go through policies and procedures and see if any of them deal with this verboten thing called reputation risk. That used to be very stylish, but not anymore. So, I really wonder, I see that as a resource problem for the CFPB. But go on and continue with what you were saying about other activities being performed at the CFPB. Not much. I haven't heard of one exam. I haven't had a client come to me and say the CFPB just knocked on their door and they're doing a full-blown exam. That hasn't happened this year. What about enforcement?
Yeah, and enforcement is happening. There is some activity there. On the debanking piece, I do want to say that we've been working with a number of banks, looking at what their account closure policies really say. I think that previously there was a big push to have this idea of reputational risk in those policies. So they were much broader policies to say that accounts would be closed for reputational risk concerns, and some banks even called out some items that they viewed as having reputational risk. That is very dangerous right now, to try to call out things and have policies that allow account closure for reputational risk, or if you do, defining kind of some of the procedures around that so that it doesn't run afoul of that executive order. That is something that can be enforced and can run into issues. And there's also state issues as well. If something comes out public at the federal level around debanking and reputational risk, you can look at Texas, Florida, Ohio. A number of states have laws that are similar. But moving on a little bit, enforcement, we are seeing some enforcement, and you see that you see some things coming out from the CFPB there. That again goes to, is the CFPB still operating?
Are you talking about new lawsuits or just out of the 42 that were pending when the administration changed? A lot of them got the new CFPB acting director dismissed them with prejudice. Maybe about half of them, but I guess some of them are still ongoing, right?
Right. Some of them are still ongoing. We saw some resolution in one back in July.
What about new lawsuits?
We have not seen new entirely de novo items being raised. It's possible that some of that is because they're having to deal with all these court actions at the moment, which does distract from being able to look at some of these other items. But that's where states are incredibly active.
Yeah, tell me about that, because I know you have focused a lot of your practice in the last several months on helping clients who are running into some big problems with some of the state regulators, particularly California, New York, some of the other AGs that where there are Democrats as Attorney General.
Yeah, I think you have some of those ones that are the known states. Then you have some that are less known as well, becoming more active too. And I think that some of what's happening as a result of this lawsuit and at the CFPB and its politicization is states are realizing that this can be a political issue and filling the gap to the extent that it exists, or going further than the gap. And so we are seeing a lot of states looking at what their authorities are, and in some instances pursuing novel strategies. We've had to engage with a number of regulatory agencies, AG's office, to discuss different things that are happening and kind of explain how our clients are operating in a number of senses. They're looking at their laws. We've talked a number of times about Cantero and the effect that has had on national banks and their preemption. States are looking at their laws and what they can enforce. And so we've been incredibly busy at the state level, I'd say. So, there's...
Yeah, and the other thing that I think is going on, at least I've seen it begin, is some of the states have taken up the what's the right word I'm looking for, the cudgel,
the baton.
Maybe the baton. That's the right word. Taking the baton from the CFPB, and cases that the CFPB dismissed with prejudice. I'm thinking very recently the lawsuit filed by New York DFS against Zelle, the the P2P payment platform. That was a lawsuit that was begun by the CFPB, but it was dismissed. And now New York DFS is taking it up. And I have it on pretty good authority that a number of states are looking at all these cases that were dismissed. And I wouldn't be surprised to see them refiled, perhaps in state court, but with complaints that look very much like what the complaints look like in federal court when the CFPB was a plaintiff.
Yeah. And now one other thing that I just want to mention, Alan, in the interest of time, another area of focus in addition to debanking is service members and veterans. This is and continues to be a focus for the CFPB, for the administration. And keep in mind that the DOJ has authority under the SCRA. And we have seen the DOJ becoming active over the past few months in SCRA investigations. So, that is also an area where, again, it's not like there's no activity out there. So there are
and
some
the
things happening.
FTC is doing stuff. right?
That's right.
Yeah. I mean, we've scheduled a webinar. It's coming up in early September with Malini Mithal, the Associate Director of I forgot what the division is called, Financial Institutions Division or something like that. And she is our featured guest, and she's going to talk about all the things that the FTC is doing. And to me, it sounded very much like business as usual, not a dramatic change, as dramatic as what we've seen at the CFPB.
I think that's exactly right. So we won't steal her thunder, and we'll let her get into that rather than what we're expecting.
Exactly. Okay. Well, we've drawn to the end of the time we've allotted for our podcast today. And Joseph, really want to thank you again for taking the time today to have this discussion and conversation with me. I guess one of the takeaways I would have is that there's still a great deal of uncertainty out there as to exactly how things are going to play out at the CFPB. And we're going to be monitoring that very closely on our blog, webinars, and on that podcast like what we've done today. So I hope we'll be able to get together probably in the not too distant future to give everybody another update. So my thanks to you for all your help today.
Well, thank you for having me on the show, Alan. Always a pleasure.
And to make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email us at podcast, that's singular, at ballardspar.com. And stay tuned each Thursday for a new episode of our show. Thank you all for listening, and have a good day.